This is Monica Perez, and I am here today again with fan favorite Eric Buchanan, a lawyer and podcaster from Tennessee who has an uncanny ability to lay out constitutional issues from an expert's perspective, but in terms we can all understand. So strap on your tanks. We're going deep with the dive master. Hey, Eric, thank you so much for giving us more of your precious time. I mean, I know how much lawyers charge, and this is some valuable landscape here. So thank you very much.
Yeah. Hi, Monica. How are you?
I'm great. I first like to tell people, give you a little background, tell people about your practice and about your podcast.
Yeah, sure. So, my practice area, we help people who have been denied disability insurance benefits. If somebody has a long term disability policy, a disability insurance policy, we have a national practice. We help people all over the United States. We can be found on the World Wide Web at buchanandisability.com. If you have a policy where the insurance company says, hey, we're just not going to pay, or they're not paying you enough, or you're not sure what to do, they're giving you the runaround. That's our little niche. We also do some health insurance and life insurance. We have 6 attorneys, and we work with other attorneys locally all over the United States. Go ahead.
You do, have you noticed any, like if you do health and life insurance and stuff, any weirdness coming out of um, the COVID time and vaccines or anything like that? Anything unusual lately?
Yeah, I mean, we haven't had a vaccine case. We do have a couple long COVID cases, people whose doctors say, yeah, you're not getting better like most people did from COVID. You're in that little category. So yeah, we've had a couple people. The brain fog seems to last for a long time, and some of those other issues, whether it's related to just COVID or the COVID plus the vaccine, the doctors are kind of sticking to the politically correct.
Yes,
Long COVID is what's causing this,
right.
and that's the point. If the doctors are willing to say that, then that gives us the kind of the footing to have the material to work with to fight the insurance company.
Any remdesivir weirdness?
No, I haven't seen any of that yet.
Okay.
The other thing, just kind of statistically, we had an uptick in cases over COVID. So people in their 50s and 60s who had medical conditions already, typically professionals, dentists, doctors, business owners. When COVID hit, it was harder to work with a disability for some people, and we seem to have more people. Just depending on what their job was, but we have more people.
Oh, I see.
It became
Right.
harder to make up the ground when you had to follow all the rules, say as a dentist, for example. So we had some extra dentist cases come in.
Right, right.
Yeah.
Very interesting. Yeah, I'm sure you're learning it's opening up whole new nuances that you didn't know would be issues. But that's great. So um what I like, and I hope this is okay with you, when I know a lawyer whom I trust, I would it doesn't even matter to me necessarily if they are actually the right lawyer for my case. I find I like to just ask them if they can recommend somebody they trust. So, hope you don't mind as a service to the listener that you're open to fielding referrals, even if they seem a little bit outside your wheelhouse.
Absolutely. We have a great team that helps people who call us. We have a referral team that works on that. So once again, find us on the web at buchanandisability.com or 877-634-2506.
See, I didn't even know that about the referrals. So, okay,
Yeah.
well, the thing that you are bringing to us is totally homework for you. It's just total extra. It's just bonus stuff for us. And I wondered if we could start where we kind of left off. There was a whole list of cases that I didn't know the real significance of, the Greenback cases, the Wheatfield cases. There's just a few of them that you had touched on, and we just couldn't get to it all. Can you help us pick up that thread and
Yeah.
tell us where
Yeah.
to start?
Yeah. So absolutely. So as somebody I was made fun of in law school by my professors for being the Federalist nerd, sort of. I didn't actually join the Federalist Society, but I like those people and kind of hung out with them.
Hold on, time out. I got to start. I'm already going to interrupt you with questions.
Okay.
I'm an anti-federalist.
Yep.
So you're a Federalist because you like the whole John Jay, Alexander Hamilton appeal to the need for a constitution, which is kind of surprising to me because you're a small government guy.
Yeah, so the conversation you and I had last time to kind of pick up was about the
Yes.
Articles of Confederation and whether or not we needed the Constitution to replace it. And my argument is the way I look at it as a small L libertarian, that the Constitution, the way it was originally written, and with most of the amendments being reasonable, provides for enough limited government but it's the appropriate amount of government for a big nation to have in the modern era. It's the way some of the Supreme Court cases have been interpreted over time that have opened the door for a giant administrative state, for the government to exercise powers beyond what was granted in the Constitution. And that's kind of where we got to this conversation today. Is it's not the Constitution itself that's the problem. It's the fact that the Supreme Court stopped following the Constitution and opened the door for this giant behemoth government that it does too much.
And I would say that even though I would have thought myself an Articles of Confederation gal, and I'm not conceding that ground, but I've always felt that when people say they want a new constitutional convention or whatever, they want to rewrite the Constitution, I've always felt that if the Constitution were followed, even just not even necessarily originalist, but I like the textualist approach. Either one of those would be fine with me. And if we could return to that, that would be a compromise that I would accept. Like I would consent to that social contract if it were actually followed. So I'm all for kind of getting back to where it went wrong and not just scrapping the whole thing. And if we can talk about some of those cases, I think it would be very illuminating.
Yeah. So, big picture, let me just kind of touch on it this way. The Constitution is broken down into different articles, and the ones that really matter are Articles 1, 2, 3, and 4. Article 1 contains the rules for the Congress, for the House of Representatives, and for the Senate. And when you go through Article 1, you get to Section 8, and basically, oh, she grabbed her pocket Constitution, ladies and gentlemen.
I
This
think
is
there's
awesome.
always one within reach.
There absolutely
Probably
should be.
two.
Yep. So when you get to Article 1, Section 8, there is basically a laundry list of those powers that the states, when they formed the Constitution, conceded or granted to the federal government, to the legislature. So Congress,
Those are the 18 enumerated powers. Is that correct?
those are the 18 enumerated powers, right? And so one of the basic arguments of constitutional law that's gone back to the very beginning is, if Congress has that list of only 18 things that they can do, is that all that they can do? Should it be all that they can do? Should they be able to do something else on the list? And so one of the fights when the anti-federalists, the founding fathers who didn't want to have a constitution, the ones who Monica would have hung out with, that you would have thought were
Patrick Henry, he's
yeah,
my man.
exactly. When they said, okay, we're losing the fight.
Hey, the country would be in a lot better. We had that argument.
Yeah, if we wanted
Okay,
to,
sorry.
yeah. So we can have that deep dive again when you want to. But if we're going to talk about this, so if the anti-federalists, when they got to the point, they said, okay, we're losing the argument, there's going to be a new constitution. Can we at least make sure that it has a Bill of Rights? And the Bill of Rights, the first 8 of the Bill of Rights are things like Congress shall not do this, infringe on your freedom of speech or religion, or the right to bear arms, or invade your privacy with unreasonable searches and seizures, the right to a civil jury trial, the right to a criminal jury trial. All those are 1 through 8. No excessive punishments. You get to about number 8.
Can I ask you, did George Mason, was he the one who, I think they didn't he write it for a different constitution, for a state constitution, and they lifted that? Because George Mason is a big libertarian. Like George Mason University is a place for that libertarians can turn to.
That's part of the story, is that he sort of started with the Virginia Constitution and some of the other constitutions and added, say, okay, well, here's the rights we can issue expressly. The big picture was those first 8 were like guaranteed rights, like the government's not going to interfere with your free speech or your right to have guns or whatever. And then the argument became, well, if you're going to list these things that government can't do and that Congress can't interfere with your free speech, the anti-federalists said, well, you shouldn't even need that list, because there's nothing in Article 1, Section 8 that gives Congress the permission to pass laws about that stuff. So why do we need a Bill of Rights if we already have this little short menu of the enumerated powers in Article 1, Section 8? And the Federalists, the ones who wanted to have a constitution and a broader role for the federal government, their counter argument was, well, just in case. We want to make sure that it's very clear that Congress can't pass these laws. And so we're going to give a list of things that they can't do, but we're going to add numbers 9 and 10. And so Amendments 9 and 10 of the Bill of Rights basically say that just because we've listed something on this list doesn't mean Congress has the power to engage in those other acts, to pass other laws, and anything we don't list on this list is reserved to the states. Any of the other
Okay.
powers are reserved to the states. That's essentially what 9 and 10 say.
I have a question.
Okay.
So is it the risk of Congress actually overstepping its bounds, which is what those first 8 amendments are for sure. Like people think they're a Bill of Rights, but what I always read them as when I really looked at them, they're just a list of limitations on the federal government. They're not a Bill of Rights because it doesn't say I can run around naked in my own house and whatever, do whatever I want, which, that's I have that right, but it's not a list of rights. It's a list, it seems to me, list of limitations on the federal government. But the reason I would say that it was necessary is because this new government had a lot more power. And I don't know, I always think this is weird. Like the Department of Justice, the FBI and stuff emerged after the Civil War. So it wasn't part of the Constitution to have an enforcement mechanism at the congressional level. And it didn't have income tax, or like it had only apportioned taxes. So I feel like to the extent Congress had enforcement and taxation, they would be tempted to overstep their bounds, whereas they didn't have that, for sure not in the Articles of Confederation. There's no mechanism for that at all, I think.
So yeah, I mean that's
Could that be true, or am I just hacking
yeah.
away?
I mean you're speaking my language here. This is the kind of stuff we can deep dive on forever. If we're going to talk about the cases that kind of changed the Constitution, we got to kind of set this up to explain the difference.
I
But
know, but I got to
but
have
you're
fun in the
yeah. I
terms of
know.
like what people can follow
Yeah,
along.
yeah, I'm with you. I'm not arguing with you about that. I'm just kind of let me get this part set up.
Okay, okay.
I argued with you last time that the Articles of Confederation were so weak that the idea that essentially you had to have the unanimous vote of every state. Every state gets one vote. So only there were 13 original states. They each get one vote in the Continental Congress that became the Congress that controlled the United States. They had no ability to raise taxes, to raise an army. So when we would have been potentially invaded by Great Britain in 1812 under the Articles of Confederation, it would have been a lot easier for Great Britain to win, and 13 individual states almost would have suffered a lot. I just think I'm sort of on the side of James Mason and Benjamin Franklin that we needed a stronger constitution, but we needed to not F it up.
Right.
and
And
you
you
know,
needed to put limits on it in case it was read overly broadly. That's what I'm just saying. What I think that
right,
the
right.
Bill of Rights is there because the Constitution was a little bit more of a robust central government.
Absolutely. So we can start with so like Benjamin Franklin was the side of we need this new constitution, we need more powers. But remember what the lady asked him when he left Independence Hall on the
Yes.
day they'd agreed to it. And what kind of government do we have, Mr. Franklin? And his answer was a republic, if you can keep it. And so what I'd like to talk about, I think where you and I agree is okay, if we're stuck with this constitution, it should be read as literally as possible. It's a set of rules. We should follow the rules. And the idea that the Constitution is going to be this limit, if you don't read it either textually or contextually, then what is the point of having a set of rules if you could if anybody can break them or change the rules whenever they want to?
And it's important to understand that the whole concept, the law, the government, the foundational documents, everything, they're coherent, they're comprehensive. So you don't, if you have this vision of how the government would work, checks and balances, liberty and consequences kind of thing, you don't want to go in and you can really bastardize a system. And I think that's exactly what happened by opening up little holes in the dam here and there. It would make the whole thing collapse because you can't have open immigration if you have like no limits welfare. Like it's just that kind of thing isn't going to work. And so I just feel like if you want a different form of government, you need a different constitution, and that it's worse to have these things that go in and take advantage of little, loopholes or whatever, because you have this extremely rich and free, I even think that on the other end of the spectrum with the corporations, if you are going to have a regulatory state, well, then this unfettered competition, it's not unfettered. It actually keeps out the new entrants. I just think that there's a lot to it. I like that. I do want to understand where those little fissures began, because I
Sure.
think that's where all the water flowed from.
Yeah, and we'll talk about a couple cases into this. We kind of get to where the dam really breaks, and there's kind of a period in history. There's a couple periods in history where the dam breaks and then breaks again. But so just to kind of simply recap that the Bill of Rights amendments number 9 and 10 essentially boil down to the fact that just because we've made a list of rights doesn't mean these rights are inclusive of all the rights people have. And that was part of article of amendment 9 and 10, and the other one basically says that those powers not delegated to Congress in this document are reserved to the people or to the states, expressly saying if it ain't on the list in Article 1 Section 8, Congress doesn't have those powers. And so from the time of the founding fathers passing that, and the first states passing that in 1789 is when the Constitution was passed. By 1792, we'd adopted the Bill of Rights, the first 10 amendments. From that time until the Civil War, effectively, Congress or the Supreme Court only applied the Constitution's rights, like you mentioned, as limits on the federal government, and that it was fairly an effective way of limiting what the federal government's power was. And there was sort of a consensus that, well, this list is the list of things we can do. And in fact, I'll just a quick down a rabbit hole. There's a famous story when Davy Crockett was a member of Congress in the 1830s that they wanted to pass a federal law providing relief where there'd been a massive fire in Georgetown and a part of the city had burned down. And Congress is right there in 1830s, right there in Washington, D.C. And he stood up and said, no, this is not one of the things that's on the list of Article 1, Section 8. Congress shouldn't pass a law providing $100,000, which was a whole lot of money in 1830, whatever, to rebuild those houses. And that was actually used against him to get him unelected, which is how he ended up heading
Wow,
off.
really?
Yeah, so everybody
That's
was, because he was mean.
that's
He was considered mean because he wanted to limit the
yeah.
powers of the
But
Constitution.
that's so interesting because it reveals that this concept of the nanny state is definitely not new.
No, that's right. And in fact, the people who originally backed him ended up not backing Davy Crockett because he didn't like provide them the pork back home in West Tennessee, because he said, no, that's not in the Constitution. And so they used this not helping out those poor people whose homes were built in Georgetown as one of the reasons to argue he should be defeated by his opponent.
Well,
So
they
we
also, yeah. I just want to say that an argument that's often used today of why the Constitution is outdated is that the founders couldn't have contemplated whatever pirates. Of course they
yeah.
did, but that they didn't contemplate these things. But of course they did. Obviously they did, because
Yeah.
they had these arguments from the get go of what the Constitution did or did not allow.
Yeah, absolutely. This is something that was being argued from the very beginning. And just to finish this for our listeners, this is one of my favorite stories. So Davy Crockett loses the support of the people who originally backed him to go to Washington. He comes home because he didn't support Congress spending money on stuff that was like picking favors, but just wanted it to be very limited. He was basically an originalist. He comes back home to Tennessee. He finds out the election results, and his entire concession speech, standing on the courthouse steps in Jackson, Tennessee, was, "You all may go to hell. I am going to Texas." And that's when he ends up a few months later at the Alamo, where
Yes,
he's killed.
yes.
Yep. So,
Oh,
all right.
yeah. Okay,
Let's let
good.
that. So
That's
let's get back. I say this. You and I have a friend, Clint Powell, and I use this kind of
yes.
way to set up these stories all the time. Let's get in our crunchy old time machine that rattles and hums, put on our dusty clothes, and we're going to go back to the time of the Civil War.
All right, the TARDIS. Let's go.
So yeah. So when we get back there, what has happened during the Civil War is the United States military was tiny at the time of the Civil War. A lot of states had militias, but the northern states eventually needed to spend a crap ton of money to fight the war. And they came up, the United States, representing the northern states that during the war, basically said, we don't have enough money. We can't borrow enough money to keep paying for all the cannons and all the guns and all the uniforms with the gold that we have and the silver that we have. We don't have an income tax. They actually put one in place during the Civil War that was not authorized, but at least it was a way to raise money. So that was kind of a constitutional violation. But the big one was that the United States government started issuing greenback money. $1 bills, $10 bills, $100 bills that were not redeemable in silver or gold. And so the fight became, well, wait a minute, there's nothing in the Constitution that says the United States Congress really has the power to issue that money. There's arguably a provision in there about them deciding the value of money, but here's it gets to this important point in this case called the greenback cases or the legal tender cases. The Supreme Court's going to absolutely agree that Congress does not have the power to issue greenback money under the Constitution. The simple facts of the case are kind of interesting. A woman from up north owns a big sheep ranch in Texas, and the Confederates during the war seize all her sheep. It's like thousands of dollars worth of sheep, which was real money in the 1860s. And after the war, she wins a lawsuit that says that the state of Texas, while acting in a state of rebellion, was not authorized to seize my sheep because they were fighting for the
Right.
Confederacy. So I'm owed back for the cost of these sheep.
By
And the
Congress, who now owns Texas again.
well, actually, no, by the farmer who bought the sheep when Texas
Oh,
seized the sheep,
wow.
the local
He
Texan
did
down
not have
there
good title.
who
Okay.
was on he didn't have good title, and he
Right.
knew he didn't have good title because it wasn't a good faith purchase for value because Texas in a state of rebellion was not authorized to seize the sheep.
Even if
The
he hadn't known, I don't think he would have good title.
Yeah, probably. But the important thing that ends up coming out of the case is this guy in Texas has to pay her whatever the debt is. Let's say it's $4,000, which was real money in the 1860s. And he then proceeds to pay her in greenback dollars.
Oh.
Well, the greenback, what had happened was these Civil War dollars were floating around all through the 1860s, and people recognized that there may be a question of whether they were constitutional or not. And by the time that she wins her case, people, just ordinary Americans all the time, were basically saying, all right, if you're paying me in gold or silver, the price is $1 for this item. If you're paying me in greenbacks, it's $2.
I have a question about if you know how exactly it worked. So I assume that the greenbacks took the line off that like this can be traded in for silver. Remember?
They never had that on there. This is
Right.
before any of that happened.
Oh, so
The
so
United States had
dollar
never
bills never had
The
that.
United States had never issued paper money before in the entire history of
Oh,
the United States. What we had bef
wow! I did not.
Yeah,
I missed that.
so what we had before the Civil War was banks issued banknotes that
Right,
were
right.
redeemable at that bank in gold and silver. The United States Bank, this was around the time
So
of
a
Andrew
banknote would
Jackson,
say worth 1 ounce of silver. It
or
wouldn't say worth silver. Like now, it says worth silver. Like I had my father had
or
like
it says $1 worth of silver, but there's a guaranteed exchange rate or something like that.
right. Okay. Yeah,
Yeah,
I
so
got you.
and going back again history again there was the whole Bank of the United States, which was a fight between the Democrats and the federal and the Whigs in the 1830s with Andrew Jackson. That was a separate independent bank. It issued banknotes, but those were not US dollars. Those were banknotes issued by a bank that was issued under under a articles of incorporation for a private entity. So up until the Civil War, there had never been US government had never issued paper
Okay,
money.
I got it.
And so because this had never happened before, basically people said, I don't trust this paper money. And there developed an exchange rate. If you're going to pay me in a banknote backed by gold, or you're going to pay me in actual gold, then the price of this item is $1. But if you're going to pay me in greenbacks, it's $2. And the case goes all the way to the Supreme Court. And this is one of this is there, let me say it this way. There are other cases we can talk about on different days if you want to have this further conversation and dive deeper where the Supreme Court had already screwed up some stuff. But this one, I think, is the first major turning point where the Supreme Court expressly says the United States Congress does not have the constitutional authority to issue paper money. But because this is so important for the government to run its operations, we find that it's an implied power. And therefore the woman has to accept the greenbacks as payment in full for her debt because there's nothing unconstitutional about the United States Congress creating greenback notes as an implied power.
But they just invented implied power.
No kidding. That's absolutely what happened.
They should have
That's
just repudiated the debt.
well,
I
I mean,
mean,
they, yeah, they were,
people
yeah.
took those greenbacks. They should have known better.
Well, that's why they were exchanging one for two, because people were arguing, well, how do we know these are going to be binding, or at least be able to make force the United States government to redeem the notes? But do you really want to have to go through that to get paid? I mean, it would have been harder for the United States to pay for what it needed to pay for during the Civil War if it hadn't issued the greenback notes, and that's essentially what the Supreme Court says. It's a practical solution to this problem created by a national crisis. But what it
But
ultimately resulted in was the Supreme Court basically throwing the Constitution out.
but haven't countries always incurred war debt that they could or could not later repay? How was that handled in the past? You know what I mean? That's what it was. It was just a war debt that they didn't repay.
Well, so what
Yeah.
Congress could have done was go to the Bank of England, which was really not on their side for most of the war because they wanted to buy their
Right.
cotton from the South, or go to the Bank of
Right.
France or the Bank of Spain and say, hey, can we borrow $10 million so we can beat up the Confederates? Now, what was Spain and England saying at that time? Well, for some reason, sir, our banks are closed to loan money to anybody who wants to cut off our supply of cotton that we
Right. We
need.
get that cheap cotton.
We get that cheap cotton. So there was political reasons that the United States was having trouble borrowing money, and just economically, in order to keep the war running, they created this
Mhm.
idea of greenback dollars to keep the economy going to get through the war. And the Supreme Court, instead of saying, all right, we've created a problem because we violated the Constitution, and maybe they could have come, I don't know how, but come up with some remedy that said, well, these are redeemable under these special circumstances, but otherwise it's unconstitutional to issue anymore. No, they just. But here's the problem: instead of finding some solution like that, the Supreme Court made up a rule, and the
Right.
rule they made up was the Ninth and Tenth Amendments don't apply. That there is no limit on Congress's power, and they expressly say just because Article 1, Section 8 has a list, that's not the entire list. There are other
Wow.
implied powers that a major government in a major nation in this modern age in the 1860s needs to have these implied powers to operate.
See, they could have said Congress had no right to do this, and now Congress has to pay it back. But they didn't because, I mean, they had to have had a reason. They can't have just because they, you understand, they just absolutely right. So is that not right? They could have just said, Congress, you do not have the right to do this, and you need to make
And then
amendments.
everybody carrying greenbacks would have gone bankrupt, and we would have
Well,
had
well,
a.
no, or Congress would have had to trade it in for gold, or actually go out then and borrow money from the other side because they'd already gone through the war. They could then have the full faith and
Yeah,
credit of the U.S. government. So why wouldn't it? So I'm just suspecting that the Supreme Court had a reason to rule it that way. They wanted to expand the power of Congress, maybe.
Well, I think it was the result of the damage that would have been caused, because if they had said these notes are not valid, were not issued legally, but the Congress has to redeem them. Imagine if you're the person holding $500 in greenbacks. Do you really want to have to be joining a lawsuit to get Congress to repay you, or whatever else the Supreme Court could? See, the Supreme Court back then still wasn't going to like craft a solution. They were just going to say yes or no, these greenbacks are constitutional or not. And so the mindset that had gone through, now we've gone through the Civil War, that Congress needs to have these implied powers to solve these problems in the case of an emergency. This was also, remember, this is the same time where the Supreme Court had basically been okay with the suspension of the writ of habeas corpus because it was a civil war,
Ugh.
and some of the other things where basically it's one of the periods in time where the Constitution gets thrown out the window because, well, it's a national emergency. Whether it's the Civil War, the Great Depression, or COVID, our courts kind of sometimes will do those big screwy things. The problem is that became part of our constitutional history, is that there is an argument that the Congress's powers are not limited to that list. Now, there's been cases more recently that I don't want to get into today, but we'll do it some other time, where some courts have basically said, now we have a problem with this, we need to bring it back. But for most of the early 20th century, it was just part of the assumption that Congress can have some implied powers, that the Article 1, Section 8 list is not the whole list. And that's the problem with the Greenbacks case.
Right. That opens the whole floodgate.
That opens the door for the idea that Constitution is not, you don't read it strictly and you don't just stick to the
Hmm.
rules.
And who was responsible for that? Who do you think was the justice, or the
Oh, I've
who do you
forgotten the
think
name.
made the call on that one?
It was a majority opinion, and I do not remember
But
the
do you
name
think that
of
it
the justice.
was that
Chief
it
Justice.
was
It was Chief Justice Chase, Chase.
was that Salmon Chase? Who was Salmon Chase?
No one questions the general constitutionally, and not very many perhaps, the general expediency of the legislation by which a note of currency has been authorized in recent years. The doubt is as to the power to declare a particular class of those notes to be legal tender in payment of pre-existing debts. That's the way he described it. In other words, he basically says, I'm just saying it's constitutional because no
Yeah.
one's arguing with me that it's not constitutional, when in fact it's clearly unconstitutional if you read the rest of the opinion.
Yeah, I wonder. He was a famous one. He did a lot of Salmon Chase, is
I
that the
think
guy's
so.
name?
Yeah.
Salmon Chase?
Yeah.
Yeah, so, he must have had a political bent. I mean, I just there had to have been some politics behind that, but okay, go ahead. So now we have this, precedent
Yep. So
that
that's
opens the
number
door to
one
a
on my
lot of new
list.
things. Yeah, okay,
Yeah,
keep going.
that's number one on my list. We'll see how far we get through this. How many of these you want to cover? I've got 7 or 8 of them today, but we'll try to get through at least a few of them. So the next one happens just 2 years later, and it's the slaughterhouse cases. So what happens in the slaughterhouse cases is that if you went down to New Orleans during the Civil War and after the Civil War, once trade started back up, it became a beef and cattle and pig processing center. You could sell your cows in St. Louis. They'd put them on a ship and take them down to New Orleans, and they would process the beef there and ship it all over the country. Plus, the restaurants in New Orleans that's when they became famous for being these fantastic restaurants. The problem was that all these little private slaughterhouses basically dumped whatever they didn't turn into meat into the Mississippi River, and the Mississippi
Yikes.
River was almost dead. When you'd
Ugh,
have the river would go down a little bit when it hadn't rained in a while.
ugh.
It was just the sides of the bank of the river were covered in all the remains and carcasses from these pigs and cows. It was just a mess. The city stank if you were anywhere near the river. If the wind was blowing in the wrong direction, it was just carnage. It was horrible. Louisiana comes up with the idea that they're going to create a separate state corporation that is going to set up a slaughtering process downriver from New Orleans, past the city, a little bit out of the wind that would go to the city. But in order to force everybody to move the slaughterhouses out of New Orleans, they basically made it illegal for anybody to operate a slaughterhouse. And everybody who wanted to keep doing it in New Orleans had to go become an employee of this new state corporation. The attorneys for the slaughterhouse operators, most of whom were white, but a few were African American, who were supposed to be protected by the 14th Amendment, argued that under the 14th Amendment, the new amendment to the Constitution had just been passed after the Civil War. The law, and this is what you and I talked about in our previous podcast, that the clause in there that said the privileges and immunities of citizens of the United States shall not be abridged, that states cannot abridge the privileges and immunities of citizens. And they argued that kind of language has been used throughout the common law to protect economic rights, my right to make a living. So my ability to own my own slaughterhouse, you can't just pass a law and take it away from me. You are abridging my rights as a citizen, including these brand new citizens that were African American. And it goes all the way to the Supreme Court, and the Supreme Court reads the Privileges and Immunities Clause in a 5-4 decision to say, no, it doesn't mean that. It doesn't mean anything close to that. It doesn't protect citizens' general rights in any way whatsoever. That the Privileges and Immunities Clause only protects the limited access of citizens to be able to access federal benefits or federal resources. So the Privileges and Immunities Clause would stop a state from stopping a citizen from going to the federal courthouse or the customs house, or to go become a soldier and go to the recruiting office, but it doesn't apply to any other right. So basically, it makes it a meaningless provision of the 14th Amendment.
Even though the 14th Amendment is also read to incorporate the Bill of Rights into state law?
So that
It
didn't happen
seems
till that didn't happen till
okay,
later. This was
okay,
the first case before they
got it.
did that.
Okay.
And so where this has echoed through history is there's a series of cases over time where the Supreme Court has said, well, technically, this sounds like something that would have fallen under the Privileges and Immunities Clause the way the founding fathers originally wrote it, but since that doesn't apply because of the slaughterhouse cases, it's a meaningless provision. It only protects your right to have access to the federal courthouse or the federal customs house. It doesn't protect any other meaningful rights. We've got to look somewhere else into the 14th Amendment to figure out if you have the right of equal protection or the right of due process of law. And that's when the courts eventually develop the doctrines of incorporation and substantive due process and procedural due process. And skip ahead, it just happened last year in the Dobbs case. In the Dobbs case that overthrew Roe versus Wade, Justice Clarence Thomas, in his dissent, says, "All right, now that we've kind of
His dissent.
in his dissent in Dobbs, he or his separate concurrence, I guess, is what it
Right.
was.
Okay.
Yeah, it's a separate concurrence. He dissented on this point, but it was a
Right. Right.
separate
Yeah.
concurrence,
I
right?
didn't like the
Yeah.
actual majority opinion. Didn't seem like the best thing it could have been. So I'll have to go reread Clarence Thomas's.
So read his separate opinion. So what he said, a lot of people tried to make political hay out of the fact that Clarence Thomas is now throwing into question the right to privacy, the right to contraception, the right to gay marriage, all these things the
Who
Supreme
would have
Court.
thunk a guy who says nothing all of a sudden just like comes
Well,
out
he's been pretty
swinging?
consistent on some of these constitutional issues,
Okay.
and what he actually says is this court is right that there's a problem with trying to find rights that existed in the Constitution under substantive due process, under a due process clause. That's not where those rights should be found. And the court is right to struggle with
Right.
whether the
Right.
right to abortion exists. But what the court really needs to do is go back and decide what were the privileges and immunities that were promised to all citizens. And it's time to throw out the slaughterhouse cases, which would therefore mean we need to reconsider not the fact that we have these rights, but the reasoning we have the right to contraception, the right to gay marriage, those rights that have been those rights that have been determined to be under substantive due process in the 14th Amendment. Justice Thomas is saying, no, go back and fix the slaughterhouse case, that those rights should be found under the Privileges and Immunities Clause. And so it's still reverberating till today that case is just,
Are there any cases that could actually that you are aware of that could call that precedent into question?
well,
Could
I
revisit
actually,
slaughterhouse?
that's a great question. I know of one case that tried, but it got settled.
Oh,
And
dang.
Yeah, and I'll just give the facts of this one very quickly. So the issue is in Tennessee, where I am, there's a law on the books that says that in order to sell coffins, you have to be a licensed funeral director. In other words, you have to go through and get your mortuary license. There's an old tradition, especially in southern towns, but also throughout the United States, for African American ministers to have a way to make money as they would sell funeral supplies off to the as a side of their church. And so in Tennessee, in order to protect the funeral home industry, they got the Tennessee legislature to pass a law that said you have to be licensed. You have to go through the school to know all about being a mortician in order to sell a coffin. And these African Americans got together. The Institute for Justice helped them fight this. It's one of the public interest firms that fights this stuff, and they ended up going to court. And the court in Tennessee, the federal court, found there was no rational basis for that law, that it was purely protectionary, because there's no reason you have to be a licensed mortician in order to simply sell the coffin. And the court expressly says, and this was 10 years ago, this is a case that should be decided under the Privileges and Immunities Clause, because the Privileges and Immunities should protect these ministers and anybody else who wants to sell a casket the right to legally sell something without dealing with the protectionism of this racket that
Boy,
wanted law to protect it.
that
And
could really change this country if people had the right to do stuff without asking permission.
yeah, so that case got decided in favor of the people who wanted to sell coffins, and then they didn't appeal it, so it only happened at the district court level. And the district court basically says, "I'd love to find that the Privilege and Immunities Clause applies, but the slaughterhouse cases keep me from doing that, so it's a substantive due process case."
Okay. uh, so what year was that? The
That was
slaughterhouse case?
1872,
And what year was the Greenback case? 65?
1870.
Oh,
So those are both back to back. We're
okay.
still in the hangover of the Civil War. Reconstruction still goes on till 1877. So we're still in that kind of time period where America's changing. We just passed the first real meaningful amendments, the 13th getting rid of slavery, the 14th with these new rights, and the 15th guaranteeing the right to vote. Those had all just happened. And I mean, literally, there are still Union troops all over the
Do you,
South,
do
that
you
kind of
think the
stuff.
14th Amendment should have been better written?
Uh, that's a good question. I think the Privileges and Immunities Clause is expressly written is pretty damn clear. That's why the slaughterhouse cases is such a um, just a troublesome case.
Here,
It's
I want to,
yeah. And part of it is that language, the privileges and immunities, is not brand new. It's been around in common law for a long, long time. Basically, it's the language that was used in common law to protect free citizens.
it's just section one. That's the that, can I read it?
Yeah,
Okay, all this is Amendment 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof, which that's a separate clause I find interesting for immigration purposes, but moving on, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. I like that one. Nor deny to any person within its jurisdiction the equal protection of the laws. So, no any law which shall abridge the privileges or immunities of citizens. And where are privileges and immunities of citizens defined?
there's a long history of common law going back to Great Britain that
Right.
basically says the privileges and immunities are those rights you have as a citizen. And generally, they were seen originally to include economic rights, which we're going to get into in a couple more cases here.
Okay, because I know that we actually did hit on some of this stuff last time, but 3 years in law school didn't actually educate me well enough to really understand this. So I think if we're trying to have this conversation in a way that the people who live under this document can understand it
Sure,
today, if it's coming up for me again, I feel like it's worth going back, and you can't do it quickly because it's harder to listen to if you just if
yeah,
if you don't revisit the things that are a little at the heart of it. So yes,
sure.
okay. So now I see that, and we are going to get into some of that, which is great. I find that question really important. Okay, so what's next?
All right, so let's skip ahead through history a little bit. The Civil War winds down. We go through this time period in the 1800s where uh, technology is starting to grow. We end up in the populist period, and that's when the populist movement. We end up getting prohibition. We end up getting the direct election of senators. We get women's right
Ugh.
to vote, and we get the income tax. Those next big four amendments come around 1900 to around between 1900 and the end of World War I and 1918. That's the time period we're talking about. Actually, the women's right to vote happens in the 1920s,
Let
but
me let me ask you a question. I think I read there's like 14 constitutional periods or something. What are they called? Epochs, or what are they called? Like
yeah,
I
I've,
think
I've heard that the constitutional epics. I just
yes,
the period's a big change is a simple way of putting it. That the
yes,
Civil War was the first big one, the populist era was the second big
right.
one, and then the third big one is basically the Great Depression and the New Deal. Uh, but
And then
some
the
of the
fourth one was like JFK and LBJ, I think,
yeah,
right? Or
really LBJ and the civil
when
rights.
they started obviously suppressing the truth about certain things, like the JFK assassination. But okay, all right. So the populist, I have a book called The Populist Moment. I should probably read it, but
Yeah, and by the way, just as a little analogy, I mean, the populist movement was such a big deal. In 1914, we had the largest ever percentage of eligible voters go vote during the populist era, and the next time that a percentage was that high was 2018. That's just the
that
parallels to what's going on
a
today.
percent was
Percentage of
that
the
yeah,
highest number of the
right,
percentage of eligible voters
yeah,
voted. The high watermark in the United States had been
yeah,
1914
right,
during the heyday of the populist era,
right.
and the next time that happened, the higher percentage voted was 2018.
I actually did. I found that 2018 number really questionable. Like, I just did not believe that many people showed up. But yes, I also noticed that because it was just such a staggering number. So you're saying people were extremely galvanized, I guess would be the thing. They got off the couch to vote because was it a was it the way it is today where the population is polarized, or do you feel like the people had a different feeling than the um,
I think it's
politicians.
I think it's a very similar comparison to what some people say is going on today, where you have the broad population of ordinary people feel like they're not being represented by the elites, that the elites have their own power structure, and therefore, but the people in a, they say, democracy, in a constitutional
Yes.
republic, the people should have more of a voice. And part of the one of the changes was allowing the direct election of senators instead of having senators picked by the state legislators, which made it so that senators didn't represent the states anymore; they represented the people.
But
Those are
what's
the
the point? It's redundant then with Congress.
exactly, and without getting too deep a dive, that is exactly the podcast that Clint and I did yesterday on
Oh, no
Notifying
way.
the People.
That's probably
Was
not even out yet.
yeah, the 17th Amendment, and also the original, what the founding fathers originally wanted to do when they had the senators elected by Congress, by each state's legislature.
Do you happen to remember? So, what when you said it was the highest, was it 1918? You said, or what year
19,
was that?
1914.
1914. So that's the war in Europe had just
The,
started,
the
August
war,
1914, and so you're talking probably
no,
November.
no,
Was it
November.
November? Was it already November as the time to vote?
Yeah,
Okay.
yeah. November's always been there.
Oh, it's just
It
the
was whether they
inauguration. Yeah.
inauguration went from March back to January. Yeah,
Okay. I want to think about this for a second. So 1918 was not
the
a
end.
presidential year. That was not a presidential year.
It
That
was
was a
19. It was
midterm.
1914. Was
Oh,
a
sorry,
midterm.
1914
Yeah,
also was not a presidential year.
yeah. It was.
That was a
It was a
midterm.
midterm. Yeah.
Okay,
Do
so
you
do
remember
you
who ran in 1912?
for president?
Yeah,
Was that Teddy Roosevelt and Winston
it was
Churchill, Woodrow Wilson,
Woodrow Wilson won.
and Taft?
Teddy Roosevelt got more votes in the Bull Moose Party that were electoral votes. So the last time a third party got electoral votes, got
Yeah.
more electoral votes
Was it Taft?
than the
Was the other
Republican.
guy?
I think it was. I think it may have been Taft. But
That's
the
pretty
point is,
good for a girl who went to
yeah,
public school.
yeah, Stanford Brainiac is what you are.
Well, I didn't learn that at Stanford. So, okay,
Yeah.
so
So
yes,
the
well, of
point is,
course he
that
did that on
everybody.
purpose, though. Teddy Roosevelt did that on purpose.
Yeah, the point was everybody was super engaged.
Oh, okay. So 1912 was when Teddy Roosevelt did that. And then
Yeah,
1914 was the midterm. So
the
Woodrow
next midterm.
Wilson got elected and he was not the people's choice. I'm sure it was not. It was a plurality and not a majority. It has to have been. Then, so you say in the midterm, people were like, what the heck? I hate this guy. And I'm sure they came out to vote in Republicans or Whigs or whatever the hell they were called back then.
Yeah,
Republicans, right?
yeah. Well, and then the remnants of the Bull Moose Party, which put up some
Mhm.
candidates in the legislature for.
All right, I'm looking this up. The 1914 midterm
Yeah,
election results. Ah,
yeah. I don't know if any of them did anything, but there was still that conversation going on because Teddy Roosevelt started the Bull Moose Party, and they actually got. It weren't the last time a third party got electoral votes, but it was the last time they got any meaningful number. They actually got more than the Republicans did in
right.
1912.
And then the next one was probably John Anderson, or who was it?
It was George Wallace.
Oh, wow. He was. Oh, right.
Yeah.
Yes. So then, but then there was another one, like when Clinton won by 44% instead of, wasn't that?
So Ross Perot got a big percentage of the popular vote, but he did not win any electoral votes. He didn't win any states.
Oh, okay. And what was John Anderson really nothing burger?
Yeah, I don't
Remember?
think. Yeah, he didn't get either a large percentage, or
Okay.
he certainly didn't get any electoral votes because the only.
Gosh, Eric, you're probably younger than I am. That is really scary because I remember John Anderson.
I remember John Anderson.
Okay.
I think we're the same age.
All right. Well, let's not probe that question. Let's just look and see. Okay.
I'm 26, Monica. I'm sure you're not any older than that.
I had to change the year of my birth on like the Twitter thing. It said, we're not going to tell anybody this. I put it in Google. Fucking blasted. Like on my birthday, it's like, happy giant number birthday. I was like, that's a private matter. Okay, it's Democrats retained control of both houses of Congress, probably because the Bull Moose Party continued to interfere. And then, of course, the Democrats get us into World War One. We can talk about that another time too.
Yep.
Okay,
Yep.
keep going.
Okay.
So now we have this new constitutional epic, the populist movement, which brings in all these constitutional amendments, one worse than the next. Can we say
Well,
that? Is that it was?
I'm kind of okay with women having the right to vote.
Hey, but a
but
lot of them had the right to vote anyway. Maybe that's not a federal issue.
Yeah, well,
I mean, how you select your electors doesn't really seem to matter to me. Like, I don't even care if you give it to like aliens from outer space. But I will say it was a good thing for the country because Harding then Coolidge won by the biggest landslides in presidential election history, thanks to women getting the vote.
Yeah, and Tennessee is where the women getting the vote. Our state legislator passed it last. We were the place to put it over the top. So if you go to the Heritage Hotel in
Oh,
downtown
there you
Nashville, there's
go.
actually a plaque. But the other ones, the income tax, I think
Yes.
it was a horrible idea.
Yes. Senate, bad. And there
The
was a
pro,
fourth one, right? The
the
FBI.
the other one was prohibition, which they ended up having to
Dang.
undo. Right? Yeah, what a bright idea prohibition was.
That's
That
crazy.
that
What?
brought us all the gang activity and
Oh,
the gangsters in the 20s and 30s.
I read, and it may be true, that Rockefeller, who was such a genius, such an evil genius, wanted to ban alcohol because Ford wanted to use alcohol to run vehicles.
Oh wow.
And Rockefeller wanted to use oil. So he was behind the Temperance League. That's what I read.
Oh wow. I
Of
hadn't heard that
course.
one before.
But that's not so far down the rabbit hole that like aliens are popping out. You could that one you might be able to to accept if I can find that evidence. Okay,
Yep.
keep going.
All right. So the populist amendments have been passed, and we're into the Roaring Twenties. And the next big case is a case called J.W. Hampton Jr. and Company versus United States. So Hampton versus the U.S.
Hmm.
This is a 1928 case, and the issue is that Congress gives the president power to set tariff rates. It's not that Congress says that the tariff rates are blank. It says, President, you can set whatever tariff rates you want to within a range to basically adjust how we're doing it in our foreign trade. And these businesses don't like that, because if that basically means the president can pick and choose the winners and losers of business, of which companies are going to have to pay higher tariffs coming in when they bring stuff into the United States. And the point is, it's not Congress passing a law saying the tariff rate is 4% or 8%. It says, Mr. President, you have the authority to simply set the tariff rates within this range of 0 to
And that's a
10%.
tax. A tax should be
That is absolutely a
Congress.
tax.
All right, so this was Hoover, and it was before the crash of 1929.
Correct. Yes. This is when Hoover was first elected. In fact,
How did he get elected? He must have been lying.
he
Because
was a
after Calvin Coolidge to want Hoover,
Hoover was a pretty smart guy. He'd done a lot of stuff well in the rebuilding
I think
Europe
he.
after World War One.
All
The
right.
Hoover Institution at Stanford
Oh yeah,
is
yeah.
a pretty great place. But
But
yeah,
he rolled over after a while. Like something happened. He
he
just
did.
didn't handle 1929 the way
I,
Harding
I
handled
Yeah,
the
I think he
crash under him.
decided that big government was the solution to a problem big government had caused, and that just was he learned
Mm,
his lesson the hard. He was wrong place at wrong time because he was there for the Great Depression.
maybe somebody
But
got to him. Okay,
in the
so he did a
Hampton,
better job than FDR. But okay, go
yeah,
ahead.
in the Hampton versus United States case, the point is this: that the Supreme Court says that's fine. You can go ahead and do that, Congress. You can delegate your power of legislation, that there is an implied power, citing the Greenback cases, that there's an implied power under Article 1, Section 8. It's not on the list, but we're going to let you do it anyway. That you can delegate a legislative power, the ability to pass a law, as long as there is, quote, an intelligible principle for the administrative agency to follow. This case is the grandmother of our giant administrative state.
Yeah, because
This
administrative law, when I started it first day at Stanford Law School, they said, I do not want to answer, do not ask the question of whether it's constitutional. It probably isn't because it's legislation by the executive branch.
Absolutely. I mean, how did the founding
Man,
fathers define tyranny?
that's how you get, well, how?
By combining the executive power and the legislative power in the same hands. And if you add judicial power to
Yes.
that, you have the complete total control. You have
And
totalitarianism.
and that's how you have also like a deep state that's unelected and is continuous over time because it has no accountability. It's
That's
not
ab-
representative.
that's absolutely right. And our administrative agencies have all three powers. The Social Security Administration is the largest judicial body in the
Wow,
world, for
yeah.
example. Uh,
Snap.
but every agency has the power to issue regulations. And this is the case that basically says we're going to open the floodgates. Congress has the power to delegate the power to create the rules, to pass the laws, instead of it having to be passed by the House and the Senate and then signed by the president. Now we're just going to say to an agency, you make it up. And and what the Supreme Court says, as long as there's an intelligible principle that the agency
That's
can follow.
pathetic.
Yeah, it's basically no limit at all.
Right.
It's basically no limit at all.
Wow. That's
Yeah.
shocking. Now, who was responsible for that? Who wrote that? Who
It
was the
was this was Congress in the 1920s, in like 1925 or 26.
Wait, but who said intelligible thing? There was a
Oh, who
law
was
passed. Yeah, who
that?
made that judicial ruling?
That was the reasoning by the Supreme Court, and
Who's
I
responsible for
don't know
that?
if I
Was
remember
that
what
Frankfurter? Who was the
I don't remember which justice. I don't know if I have that.
Sorry, buddy. I hate to say that, but
That's
I like
okay.
to put names with these kind of crimes because I always think that they have been politically motivated.
Yeah, I do not have the name of
What
that
year was
justice,
it?
but this is 1928, Hampton versus United States. Um, so just this, I'll give an example of how this carries on to today. When you're ready, Gundy versus United States, which is
Hold
a 20.
on.
Yep.
William Howard Taft was the supreme the
was he
was
the
the yeah.
was he the justice who wrote it?
No, but it was the Taft court.
Okay.
I'm
Yeah,
laying it at his feet
I'm not sure who wrote it.
unless he
So
was in
so
the
an
minority.
example of how this delegating of federal powers has gotten so bad that Congress can pass it on. Gundy versus United States Supreme Court held that 42 USC 16913D, what that is in plain English, the Sex Offender Registration Notification Act does not violate the non-delegation doctrine when it allows attorney generals to decide who has to register as a sex offender. So it's not Congress defining who has to register as a sex offender. Congress delegates to the attorney general to write the regulation to define who can be registered as a sex offender.
So the
And
federal law, the congressional law is sorry, the sex offender registry is a congressional law, is products of a congressional law.
yeah, that's the SORNA, Sex Offender Registration Notification Act. There's a federal sex offender act.
Okay. And that totally violates the police powers in the 10th Amendment, right?
Well, it violates the fact that there are no police powers in Article 1, Section 8. Yeah. The Article 1, Section
Right.
8 does not say Congress has the power to have police powers. And the argument, I guess, would be because the Supreme Court didn't even address whether they had the power to pass the law in terms of the powers found in the Article 1, Section 8. What they actually said was the way they decided the issue is this is within the permissibility of delegating a legislative authority because as long as there's an intelligible principle, this fits within the Hampton versus U.S. case. And this is in 2019 that the Supreme Court said this in Gundy.
Oh, wow.
Yeah. Gundy versus U.S. Is
See, it
2019.
seems to me that that would violate like the Fifth Amendment because you
Like
you
it's an
need
ex
to be
post facto law
well,
or
like
that it's.
you're not being adjudicated in a trial by your peers. Is that the fifth or is that the sixth? So that your punishment, like 3 strikes, you're out, for example, seems to me totally unconstitutional because you're not getting an individual trial by a jury of your peers. To have a thing like they're forced to give you a certain punishment,
Yeah.
even if it's not, the jury doesn't find that punishment because the jury has the right also to sentence.
Yeah, I'm with you that there's been a lot of this happen in the 20th century that the right to a jury trial under the Sixth Amendment doesn't necessarily means the jury has the right to issue the sentence. So all those sentencing guideline cases, all of those type of cases is where the Supreme Court has basically said no, those are okay to have those rules, and judges and juries have to follow them.
But they're
Uh,
not in Section 1, Article 8.
right, they're not in right
Was
section
it?
one, section one, Article 1, Section 8.
Section 8, sorry.
Yeah,
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 there is
Article
no.
1, Section 8, yeah. The authority to issue those kind of criminal laws. All right. Ready for the next fun one?
Um, yes, thank you, but I have to say, my brain is not yet full, but if we get too in depth, my brain fills up. So yes, it's good to move on to the next one. Go ahead.
Yeah, there's this one's good, and there's maybe one after if you want to get to it.
No,
So
we can keep going. If you can
yeah,
go till half past, I'm good.
yep, yep,
I'm
good.
good.
Then there's two or three more.
Great.
The next one is the one we talked about last time called the Wheatfield cases. The original name
Yes, I've been
Wickard.
dying to hear
Yeah,
about that.
Wickard versus Filburn. So under Wickard versus Filburn, what happened was under FDR, the Congress created um, a government agency that would regulate the price of agricultural products. And the idea was to ensure that farmers would be paid enough, but that the prices wouldn't fluctuate too much. It basically was very much a top down heavy handed taking over of the economy type law. I mean, this is seriously, if people are complaining about socialism today,
Yeah,
go back and look at what the New Deal did. This is serious government
because
control of the
yeah,
economy.
of the means of production, of actually taking that, yes, micromanaging at the highest levels, the, supply.
Absolutely. And so what the government did, what the New Deal program did, is it basically said, we're going to look and see what size farm you are, and we're going to look at the type of wheat you have or whatever you're growing, cows or whatever. And under our formulas and calculations, we're going to calculate how much wheat you're allowed to grow if you're a wheat farmer, and you have to follow that. And if you grow more wheat than that,
My
you get fined.
gosh!
It was that
That's
level.
like that's like Stalin type stuff, like, you know?
It was called the Agricultural Adjustment Act of 1938.
Dang.
And yeah, this happened right after Stalin had done basically the same thing to
Yes.
Ukraine, just did it more malevolently to purposely starve people. This is sort of more just totalitarian. We're going to control everybody. Anybody who complain, and I have plenty of complaints about the way our government is controlling stuff now. But if you go back and look at the
Right.
New Deal, holy crap!
I wonder how he came back. I'm not gonna get you on that tangent, and you don't think they were trying to starve people on purpose?
No, I think they were trying to micromanage everything because they were a bunch of expert progressives and they knew better than everybody else. They weren't doing it on purpose. They're just experts and they're arrogant.
And that was
Eh,
around the when Keynes was gaining popularity, so it would all go
Keynes
in
was
this
gaining
new
popularity, but remember,
paradigm of
Professor Woodrow Wilson from Princeton had
oy
come in
vey.
with all these great ideas that the founding fathers were wrong, that people shouldn't be able to make up their own minds. If we get these apolitical experts to come in, they'll run everything better than people will.
Well,
We just
that's
need
why
the
they had to
expert.
rig that election.
That was the whole point of progressivism, was to basically let the experts do what they do best, and so this was part of that.
Okay, and by coincidence, it ushered in all these regulatory barriers to entry, which result in more power at the top, not less. But again, for another time.
Yep, yep, absolutely. We can dive deep on that. So what happens in this case is the farmer, Mr. Wickard, basically says, "All right, I understand I'm only allowed to grow 9 acres for sale, but I'm going to grow 3 acres over here to feed my own family and to feed my own cattle and to feed my own livestock." And the government bureaucrats, you think they're bad now? Guess what? They came in. They, oh, whoa, we just measured your acreage, and you have more than 9.1 acres. You have 12 acres, and therefore here's your fine for how many thousands of dollars for going in excess of what you're allowed to grow. Mr. Wickard hires an attorney. It ends up going to the Supreme Court, and his argument is that Article 1, Section 8 has this list of powers. One of the powers that Congress has is to regulate interstate commerce. But if I'm growing my own wheat on my private land, that is not something that affects interstate commerce. Therefore, Congress cannot regulate it. And what does the Supreme Court say? The fact that you have the wheat but are not going to grow it, not going to sell it in interstate commerce, means you are not going to be purchasing wheat to feed your cattle at interstate commerce. And so it has an effect, even it's pretty damn nebulous, it has an effect on interstate commerce because it's affecting the total amount of wheat that can be purchased and bought in interstate commerce. So you growing it on your own land where you might not buy it in interstate commerce makes it enough of a relation to interstate commerce that Congress can now regulate what you grow on your own land.
That barely passes an intelligibility test. I know that that doesn't apply to this case, but
It's
it's
almost hard to
barely
explain, right? It's so
yes.
stupid. Yeah.
Yes, and I have to say though, you say like, "Oh, look at that, it was so much worse," and I'm with you there. However, in the COVID time, they came and slaughtered a lot of animals and shut down factories and everything under the cover of a health emergency, but their overreach, I think, was, comparable.
Amen.
Yeah. I
Yeah.
mean, hopefully that it didn't set a precedent that anybody's willing to pick up anytime soon, but that was, they did it. They just maybe couldn't get away with it. So it's maybe hopeful that a time that was had a trend of that kind of overreach was reversed a little bit. I hope we get to that.
Yeah, I hope so.
I
We'll
hope you
see.
can tell me how this stuff that they were way overreaching, but keep going.
Yep. So the other case I want to talk about. So Wicker versus Filburn actually didn't get decided until during World War II, basically during 1942. But there
What?
that so the
Really?
it was 1938 was when the federal government passed the Agricultural Adjustment Act of 1938. So that's when they started micromanaging how much wheat everybody had.
Okay.
There'd been a couple other cases right before that, though, and I think these are important. And the West Coast Hotel versus Parish, 1937, and United States versus Caroline Products, 1938. In West Coast Hotel versus Parish, the question was, do does the government have the power to interfere in your economic activity? Do you have a substantive right under the 14th Amendment to engage in contracts and run a business? Is that a right protected by the Constitution? And so there'd been a line of cases that all resulted in a case called the Lochner case,
Mhm.
and Lochner basically said your economic liberty is just as important liberty as your free speech liberty. Your economic liberty is something that's protected by the Bill of Rights and that is incorporated into the 14th Amendment, that states can't just come in and arbitrarily shut down your business just because they feel like it. They can't just arbitrarily say that you have to pay a certain wage, that people have the freedom of contract.
Is that
That
where
you
it was a taking or not?
no,
Is that not a
no,
taking?
no.
On
It's your economic liberty, your ability to engage in in
Okay, got it.
capitalism is a protected liberty the same way free speech and freedom of religion are protected.
So that goes back
That
to
was
the
the Lochner
slaughterhouse
case.
cases?
Well, that actually the Lochner case was from the 1920s, but it had been a line of cases that had said they basically didn't. They said the slaughterhouse case is kind of limited to how do you define the privileges and immunities clause,
Got it,
but the
okay.
next sentence under the 14th Amendment, that the government cannot interfere with your due process. The doctrine that was created to replace the privileges and immunities clause was the substantive due process clause under the substantive due process under that clause in the 14th Amendment. Clause guarantees actual rights. That's what substantive due process means.
I'm gonna make you explain that a little bit more. What so you're saying in the 14th Amendment, I read you section 1. Are you saying this
So
substantive due
so when
process is implied in section 2?
when you get done with the part that says privilege and immunities for each citizen, for every
Oh,
citizen,
right, okay.
what's
Nor
the
shall
next
any state deprive any person of life, liberty, or property without due process of law,
pause
nor
right
denied any person
right.
just
No
okay.
denied any person life, liberty, or property without the due process of law.
And liberty includes economic liberty, you're saying.
Yeah, life and liberty include your those rights that were guaranteed, that are more than just what's limited in the listed in the Constitution and the Bill of Rights, but other rights as well. And it's what is used to incorporate the Bill of Rights into the states, that after the Civil War, the Supreme Court starts to say, well, it's not okay
Oh!
for Alabama to shut down, for
Oh.
Alabama to have its own church, to have a state-run church. It's not okay for Tennessee to make your speech illegal. All of those rules, the Supreme Court can't use privileges and immunities because of the Slaughterhouse case.
Oh, I
So
thought
they
that is what they use. No,
Yeah,
okay.
so they
Uh, s
created this new mechanism. They created the concept of substantive due process to say, if you can't be denied your life, liberty, or property without the due process of law, that means you have certain rights to your life and your property and your liberty that are protected under law.
Well, but
And
but also can be removed by law. Otherwise, it wouldn't say without due process of law. So what due process of law could deprive you of your life, liberty, or property? What is due process exactly? Is it whatever the law says, or is it objective?
so what ends up happening is the Supreme Court defines certain rights to say we're going to use strict scrutiny, to say that if the right that you have not to be discriminated against because you're black or because you're Asian or whatever, that is actually we're kind of jumping ahead a little bit because this is what the court gets into
Alright.
Caroline products in
Okay.
a second.
I can
But
wait.
essentially, it's the idea that there are certain rights that the court's going to look at what the government has passed, and we're going to look at with a very careful eye. That's called strict scrutiny. We're going to look at it with the intermediate scrutiny. There better be a good government reason for the law, and that usually applies to sex discrimination. And then there's rational basis scrutiny. Basically, there has to be a reason for the government to do it, but as long as they can come up with an a reason, they can do whatever the hell they want to you. And that's the different ways that substantive due process has been broken down. And this is part of, by the way, going back to the early part of our conversation, what Justice Thomas is all about in the Dobbs decision that he's said in previous decisions. The reason it's so difficult to explain all this is because substantive due process is not a clear textual basis to create these rights, but privileges and immunities is. If you go back and look at the
Right.
common law definition of privileges and immunities, but the slaughterhouse cases threw that out. And we've been dealing with slaughterhouse cases since 1872. That's
Wow. I
150,
mean,
150 years. The Supreme Court's gotten it wrong. And Justice Thomas, an African American, is saying, no, you got this wrong.
why do you think he's doing this now? Because the court
He's been
is
doing it.
comprised, right? Okay,
He's
but
been doing it since
there's
the beginning.
hope
There's hope
because
because there's now,
there's other
for the first
people
time in a
there.
long time, there are constitutionalists on the Supreme Court, at least enough of them. You
Yeah,
don't
half
have a
those
Justice
guys make
Kennedy,
my skin crawl, but I guess they can.
but they're
I
not
mean,
Justice O'Connor, where
yeah, yeah.
whether the law is constitutional or not is a factor in determining whether the law is
Ah!
constitutional. She literally said that.
Dang,
That's-
Republican appointee too, right?
yeah, she uses balancing tests. Anyway, we're
Hey.
really going off for a second.
Oh,
Let me
come
give you.
on. Live a little, Eric. Live a little. Okay, no, keep going.
All right, so in West Coast Hotel, the state of Washington passed a law that said women and children need special protection because they're so vulnerable. And the state of Washington creates a commission that will set minimum wages for women who are working and children who are working. So it's a minimum wage law, only applying to women and children. Men don't need this
Mhm.
special protection. Women, being the vulnerable people they are, according to the state of Washington in 1930 something, passes this law. And what happens is a hotel owner doesn't pay his maids the minimum wage, and he says, under Lochner, I have the constitutional right to protect my economic liberty, and they have the right to work here if they want to. They don't have to work here. The ladies can go work somewhere else. But if they choose to work for me for 25 cents an hour instead of 35 cents an hour, which is required by Washington state law, that should be their choice, and it'd be my choice to whether to hire them. And Lochner basically had kind of said that was right. Lochner had addressed that question a few years earlier. And the Supreme Court basically said, no, substantive due process does not provide a special protection for economic liberty. Lochner gets thrown out. Your right to engage in capitalism, to engage in the protection of your property, to engage in to do with your property what you want to, is entitled to no more protection than anything, and so it can be thrown out under the quote the due process of law as long as they pass the law legally. It doesn't have to have. It only has to have a rational basis.
So that's 1937?
That's 1937.
All right, so let me ask you, that couldn't override the Fifth or Sixth Amendment or whatever gets you a jury trial, right? Because in my mind, anything that could, because the
So the
jury
so
trial
the
has
the
like,
right, the
yeah,
Sixth Amendment still gets your right to jury trial, but if government wants to pass a rule that
right,
says if you have any water on your land, we can
yeah,
deem that to be wetlands, and you can't build a house there.
right,
You don't have the economic liberty to say I can build a house. What if you say I want
right,
to? Here's a great one. As a free adult human being, what if I want to engage in a transaction where somebody pays me to have sex with them? Why is that not my right as a free person to have the liberty to do that? My wife would be awfully mad, and that would be between me and her. But if a prostitute wants to engage in that activity, why doesn't he or she have the legal right to? Why isn't there some protection for them to use their body that way? My body, my choice, kind of thing.
yeah,
Or if I want to sell some other legal product, why can government
yeah,
come along and control what I'm allowed to sell? Like, for
eh,
example, an African American minister in the South selling coffins to supplement his income,
right,
right? Those economic liberties. And Lochner had said that your right, the Supreme Court in Lochner in the 1920s has said your right to engage in commerce, to hire or fire people, that right to contract for both individuals, the employee and the employer. I'm willing to work for this many cents an hour, and I'm willing to pay somebody this many cents an hour. That is a protected right, and Congress can't, or states can't interfere with that right without a very good reason. Or maybe they can't do it at all, but they should have a
Right.
really good reason.
And now they
And
only need
West
an
Coast Hotel
intelligible
says
reason, any reason.
they don't need any reason. As long as they only need a reasonable reason.
Oh, yeah, that came up recently. That came up under the Trump administration where they said it was a really it was a really sideways thing. It was that commerce secretary, the Rothschild guy, the old guy who it was a big, big case. It was a big deal. And they said he's doing this with no reason. And I think he said, I don't need a reason. Okay, I'm going to find that. Keep talking.
Sure. So the companion case the very next year is the case United States versus Caroline Products, where the Supreme Court has their famous footnote 4. Um, Vivek Ramaswamy just talked about this, not in Woke Incorporated, but his next book about the I can't remember the name of the book, but it's about the victimhood of and why everybody's claiming victim status, and he traces it back to this case. So let me explain what we're talking about here. So the issue in the case of Caroline Products is um, that the the federal government passes a rule that doesn't allow people to sell reconstituted milk unless it's reconstituted with milk fat. There was a process developed that would allow like condensed milk to be shipped, and then you would add like uh, vegetable oil to it, and it kind of looked and tasted like
Yeah.
milk, but it was easier to ship. And basically, there became this kind of an industry in this cheaper milk, because this is before refrigeration was very common, and it was a way to ship milk, and it was cheaper and easier to reconstitute it with vegetable oil instead of dairy oil, instead of dairy fat. And so basically, the federal government decided in the 1930s this is one of the things they were going to outlaw. They just decided you can't sell this kind of milk, and the Caroline Product says, no, wait a minute, this is something we sell. It goes all the way to Supreme Court, and the Supreme Court clarifies in this famous footnote 4. They give this breakdown that for most laws, the court, I mean, the legislature only has to show a rational basis for the law. Was it rational? Is there a rational reason? Otherwise, they can do whatever the hell they want to. So there is no protection for economic freedoms. What they also say in note 4 is for certain groups of people that historically have not had a voice, have historically been persecuted, and historically don't have any power, the court can apply a much higher standard. So basically, for discrimination against African
Right.
Americans, we use strict scrutiny.
Why?
Later,
Because it
because that,
shocks the conscience or what?
because that's a right that they don't have any way to protect themselves through the political process. If they're so
Okay.
victimized that they're excluded from the political process, the court has to go in using strict scrutiny. But if you're just a dairy producer, you can engage in the political process and convince the legislator to pass a law allowing you to sell this kind of milk. But if you're excluded from the political process because you've been denied the right to vote or whatever,
Right.
then courts will use strict scrutiny. And for women who kind of have been seen as weaker and less powerful, we're going to use intermediate scrutiny. That there has to be a good reason to
This just
treat
sounds
them
like a
differently.
bunch of, it's just make it up as you go along.
Well, this actually is pretty common. Like most of the 20th century um, uh, decisions on rights are based on this footnote, and it kind of carries on and is used during the civil rights era. And essentially, it's so if somebody wants to discriminate on the basis of race, or if somebody wants to discriminate on the fundamental rights of freedom of speech or freedom of religion, courts will use strict scrutiny. On basis of sex, it's intermediate scrutiny. But if we want to regulate some kind of a business thing, it's just rational basis. We can decide whether we want to. Or guns, by the way, for
But I
some
just
reason.
don't know why they would distinguish between race and gender. Like I just it seems to me that they're just two totally different. It's either of the nature that you are disempowered, disenfranchised, which, you know,
So when they had this reasoning, when this reasoning was developed, the argument would be for race, what can you explain any time you would really need to use race as distinguishing fact to treat somebody differently?
oh,
And then
but
that
there
leads,
are times when you could do that against women
yeah,
because
It's
female prostitute, it doesn't perform the same function as a male prostitute. I
yeah.
mean, I'm just saying that
So
that's a legitimate distinction.
yeah under
I think it is.
under the original analysis, they might have argued, well, is it okay for us to generally ban women from being firemen? Because everybody knows what a fireman's got to do is carry a grown human being off of a third floor window and down a ladder.
Right.
Is that would be the
Okay.
analysis that was
Thank you.
used back in the
I
yeah.
appreciate your explaining that to me. And I will tell you, the thing I was thinking of was Wilbur Ross made a decision about how to execute the census. That they do you remember that they said he had no reasonable? It was a totally unusual thing, and the idea is that he supposedly lied to Congress about the reasons for putting
Oh,
it.
this is when they wanted to include a citizenship question
Yes,
in the all
the
right. So
decennial census.
yeah, so the argument in that case was actually that it wasn't that uh, the Congress was passing a law that would be defined under rational basis, but the review of a new regulation falls under arbitrary and capricious review.
Oh, I did not understand because it says
Yeah,
they could not ignore the disconnect between the decision made and the explanation given. And you're saying because
because
that he was held to a higher standard as an administrative
well,
guy.
actually, the standard is different, but it works out to sort of be the same. That an agency's decision to issue a
Oh, arbitrary
regulation
and capricious. Yeah.
is defined is considered to be valid unless it's arbitrary and capricious. And the slight difference is under arbitrary and capricious for a regulation, they at least need to give a reason. They need
Right.
to at least explain it so it doesn't look arbitrary on its face.
Well, then
And
the
that
Supreme Court was wrong on their what they said about Wilbur Ross, although they let him go. They didn't prosecute it, but or whatever.
well, they threw out the regulation so that they couldn't put the citizenship question
Oh,
on the
okay.
census. And that was
Okay.
the whole point of it. And they remanded it back to give them a chance to issue a new
I
reason.
knew you would
But
know it know it
then the
right off the
census had
top of
been
your
issued.
head.
Yeah, but then the census had been sent out.
I mean, seriously, I don't think I could ever stump you. I'm gonna make that my job to just throw stuff at you the whole time just to get you off track and make you answer these random questions.
I
No,
love
I'm
it.
kidding. I'm
All right,
not gonna do that. But you rise to the occasion.
so
Okay, keep going.
one more case to kind of round out this set of cases. There's other cases out there we can talk about for different issues, but my next favorite one that really shows where where the Supreme Court got the Constitution off the rails, ran over it, and kind of crumpled it up and threw it in the fire. Chevron versus Natural Resources Defense Council Inc. This is one of those cases that we all studied in administrative law, and the basic issue in
What year?
Chevron. This is 1984. This is
Nice.
smack in the middle of Ronald Reagan's time in office. The issue in the case was that there was a rule under the Environmental Protection Act rules that said that if you build a new factory, that you have to submit a permitting process to show that your pollution stayed below certain levels, and the EPA would be allowed to regulate that. They also had a rule that said if you significantly change your factory to, let's say, add a new building that has its own engines and smokestacks or whatever, that you similarly had to get that permitted. The Reagan administration had the EPA change the rule to say if you could modify your whole plant so that the net pollution didn't increase, you don't have to go through the permitting process. You could avoid the permitting process entirely. And the what's the group called? The Natural Resources Defense Council Inc., the watermelons, and I'm sorry for sounding political about that, but
Green on the outside, red on the inside.
yeah,
That's
the
a
environment,
Delling poll. That's
yes,
the
yeah,
Delling poll book.
yeah. The environmentalist basically went screaming into court and said, you can't do that because the whole idea of the EPA regulation
Yeah.
as it existed was to not increase
Yeah.
pollution, but to also require all
Right.
these extra
You cure it.
steps
Yeah.
to make it even harder to build
Right.
new industry. They didn't like that. And the Reagan administration, which we all as people who kind of lean conservative think he was pretty good on a lot of issues. If we lean conservative or libertarian, he wasn't so bad.
Until
Well,
you look at the national debt, but I did love it. I did love
so
him.
his administration's motivation in this case was to make it easier for agencies to withdraw regulations or change them so that they would be easier to make good for business to
Accommodate.
follow, easy, yeah, for to work better with business, to allow for less regulatory impact on businesses. But in order to achieve that, they needed to have a rule that made them easier for changing a regulation and to simply allow the agencies to change the regulations to fit whatever the administration wanted to do. The ultimate result of that, though, was this horrible Supreme Court decision. And the Supreme Court decision, that's called the Chevron rule, says that if an agency issues a rule, the way you answer the question whether the rule is legal or not, the agency regulation, whether it's permissible, is whether the new rule is based on a permissible construction of the statute. So when Congress creates this law called the Environmental Protection Act and says the Environmental Protection Agency is created and it can do the following, and if the EPA wants to do whatever the hell they want to under that, all they have to do is show that they have a permissible construction of the statute that allows them to do it. And step two, so long as Congress has not spoken directly on the issue. In other words, what that means is the agency's interpretation of their own power is wins. There's no there's nothing
So that's
stopping.
why it's all three branches together.
Yeah, so the agency creating their own rules gets to make up whatever rules they want to, as long as it's, quote, a permissible construction of the statute. So as long as it's even if you would read it differently, even if it's an ambiguous reading of the statute, even if there's alternative readings for the statute, as long as the way you as the agency want to read it, as long as it's one of the ways it could be read to give you the power to do it, then you have the power to do it. And the only way that you can be stopped is Congress has to specifically say, no, this is not a way to issue a regulation.
Wow.
So agencies have total power now to do whatever they want to. Now, the good news is the West Virginia versus EPA case that just came out kind of put this back on
Yes.
its heels.
Why was that so important?
So in the West Virginia versus EPA case, the Obama administration tried to create a regulation that basically said, at a national level, the amount of coal-fired plants and oil-fired plants had to be reduced and switched to natural gas and eventually to clean energy. And the argument that they were making is that they had the power to do that under the ability to regulate the specific power plants. And so what they said is, well, it's not just to regulate the specific power plants, but to regulate the entire nation as an industry as a whole. So they issued a regulation that said, we don't care what your actual output is, you one company right here, you have to meet certain standards by 2025 and by 2030 or whatever years the goals were set for, in order for the national total emissions from coal-fired plants to be reduced. So basically, it was a cap on how many coal-fired plants there could be in the nation, and the Obama administration was using the part of the Environmental Protection Act that actually only allowed them to regulate the output, the amount of pollution that an individual power plant was putting out. So it clearly goes beyond what the statute said. And what ends up happening is that the Obama administration puts this regulation out there, it gets challenged, and then when Trump comes into power, he changes it, gets rid of this program, and so it goes away. But then the the Biden, I did it again. The
Whatever.
Biden administration, yeah, the
The O
Democrats,
Biden
the
administration.
Biden administration. So Biden comes in and promptly reinstates the Obama regulations. And basically, it's the Environmental Protection Agency is allowed to just arbitrarily cap how much coal production of energy there is and how much natural gas production there is under this really broad reading of the statute that the Supreme Court looks into and says this was clearly intended to regulate how much pollution an individual factory would put out or an individual power plant, not the whole nation as a whole. That's going too far. And so the good news is the Supreme Court basically ignored Chevron and said, we don't care if this is a permissible interpretation of the statute, which is what Biden had been arguing and that Obama had been arguing before, but instead said, this is such a significant, important question. It's a major question. It's such an effect on the economy and the nation as a whole that we're going to say the Chevron rule doesn't apply and that Congress needs to actually expressly give you permission to do this because of what they call now the major question doctrine, which is now our Supreme Court clawing back the Chevron doctrine. Chevron
So,
still has a lot of weight, but if it's
okay.
really a big deal, like regulating all the power
Yeah,
plants in the United States,
right.
that's a major question. The Supreme Court's willing to not follow Chevron.
So even if Congress goes back and rewrites the statute, we have a precedent that we like.
Absolutely. Now, Congress could, if they wanted to, go back and say,
Not
"Yeah,
today.
you can have
I
these
don't think it's
limits."
gonna happen this round, right?
I don't think so, but I haven't seen the latest numbers. The House is getting awfully close. I'm
Oh, is it?
crossing finger. Yeah,
Wow.
yeah. I think the
See, I've been
Republicans
watching
probably will take.
Fox, not CNN, so I get
I
skewed.
flipped back and forth between the two just to see, but yeah, we're recording this on the day after the election. Who knows
Yes, it's
what the
November 9th, 2022.
at 3:30 Eastern time? We still don't know.
And the Senate is gonna go down to a Georgia runoff with Warnock again.
Go down to the devil went down to Georgia again.
Wow, that is nutty
Yeah,
nuts.
and that I think Nevada hasn't been called for the Senate race either, has it?
Yeah. Um,
Nevada, the Republicans
uh,
had a chance, but
so
it's
according to Fox, the Republicans have 206, the Democrats have 176 right now, and there's 53 left. The Senate, it's 49 Republicans, 48 Democrats, and there are 3 left to call.
so last I looked, it was Wisconsin, Nevada, and Arizona, and then Georgia. Which one of those has been called?
Oh, please, dang it. Well, I can't just click on it. So, oh, what? Which one? Say, I can tell by looking at the map. Maybe. What are
So
the
it
ones
was
that you think?
Georgia was going to be a runoff. It sounds like
Right.
the other
Yep.
three that they hadn't decided the last time I looked, it was Wisconsin was leaning red, but it was still open. Nevada was still leaning red, was still open, and Arizona is leaning blue, but it's still open.
I have to do my little UConn thing to see. Nevada looks. Oh, Nevada is not called. I see Nevada.
So it must be Wisconsin. Finally got called. Johnson won.
And what was the third one? Oh,
Uh,
yes.
Arizona because they're still
Johnson
counting all the
won.
paper
Johnson
batting.
was called.
Okay.
Johnson was
Yeah,
called.
Arizona, they're gonna be counting paper ballots in boxes and having lawsuits for the
Oh, yeah.
next
Arizona is.
a dumpster fire. And
Exactly.
here I'm gonna make my political comment for the day. And who is the public official who's supposed to be in charge of making sure elections are run smoothly in Arizona?
The same one who did for the
The
Trump thing.
Secretary of State.
Isn't that the one running?
Yeah, that's Katie Hobbs. She's running for governor. She's Secretary of State, so she's supposed to be in charge of managing her own election. Of course, it turned into a dumpster fire.
And she's their presumptive winner, right?
Yeah, she was
So,
leading last time I checked. So I'm just
well, of course, though.
Yeah. Well, the whole important thing is make sure Carrie Lake looks like an election denier. That's the whole point.
Yes, yes, yes. That is such a good point. Okay, I think that unless you have something to put a point on this, where
So I'm
we
going to give
got
you
the
I'm going to give
equal.
you one more from the
All right,
Reagan era, and then we're going to
go for
wrap it
it.
up. Mistrada versus the United States. The U.S. Federal Sentencing Guidelines and Sentencing Reform Act of 1984. You talked about this earlier, that the Sixth Amendment guarantees your right to a jury trial. The Congress during those early days of the 80s and 90s when they were passing the criminal laws, one of the Nevada doesn't stop receiving mail ballots till Friday. Somebody just chimed in. That's a good point. So we won't see what they do. So in Mistrada, the federal government created sentencing guidelines, but the way that they did it was they appointed a commission within the judicial branch that's unreviewable. There's no way for anybody to sue to say these guidelines are wrong, and as they'll be applied to me that they're wrong, except as a just deny. Once you've been sentenced, then you appeal to say this was unconstitutional for them to follow these guidelines. And the Supreme Court listened to this language that they used to find it constitutional for the Supreme Court, for the Congress, to create a commission the commission would then decide what the sentence is for breaking certain laws in the United States. Because Congress must be able to delegate broad general directives in our modern complex society, laws like this are necessary.
Read that again.
Because Congress must be able to delegate broad general directives in our modern complex society, this law is constitutional.
That's wrong on several levels. First of all, they've created the complexity, and I hate that argument because if they stop tweaking everything, we would a little laissez-faire would decomplexify a lot of stuff. And it's a personal right. This is an individual right that is actually expressed in the Bill of Rights.
Yeah, the right to a jury trial in the Sixth Amendment. The breakdown is, but the jury can decide if you're guilty or not, but we can pass rules that says what the
No.
sentences have to be in what range. I'm with you,
Boo.
Monica. I agree. But
Wrong.
this is why it's on my list
What
of
year was that one?
that was 1989. So this
All
was
right,
a
we got it.
Reagan era law that was tough on crime, so we're going to be tough on crime by violating the Constitution. So
Maybe,
the
Clarence Thomas will check this one out. Maybe there's something in the pipe. Do you have any hope that that's going to get? Because I hate that stuff. Do you think is that on the chopping block at all?
This is a great question. This is sort of another, like, let's go down this rabbit hole, but I'm going to try to be quick about it. There are 6 votes right now in the Supreme Court that I think would regularly re-examine any of these cases I've talked
Ah, that
about
would be so cool.
and go in the right direction. The problem is if you just ask them as law professors, what do you think? I bet you all 6 of the conservatives would agree with what you and I've just talked about, that these cases were wrongly decided. The problem is you've got Justice Roberts especially, and then
Ugh.
you've got some of the other ones sort of a little, that think about the politics. And when you have the reaction that we've had to the Dobbs decision, and you have some of the other political pressure being put on the Supreme Court, when somebody shows up at a justice's house with guns and zip ties, are our 6 Supreme Court justices that are conservative, are they going to let that influence them? One footnote to that before you answer
Mhm.
is when the Supreme Court went the sideways on that Wickard versus Filburn case, and also that West Coast Hotel overruling Lochner, that was around the time that FDR had a huge majority of Democrats in the Congress, and they were
Oh, yeah.
threatening to pack the court.
That's
When's the
right.
next time in American history
Yes.
you heard a serious talk about threatening to pack the court? Right now, that somebody's threatening the Democrats' ability to do whatever they want to.
See, there you go. That's the kind of dirt I'm looking for. That's the kind of, soap opera-y stuff that I expect from these kind of weird, irrational cases. But I have to say, this is weird. And I think I mentioned this to you before, but it just keeps popping up. When I was on the radio, is when Obamacare passed. I was very active against that. And it was Justice Roberts who made up this thing that was impossible. He said, it's a tax, but it couldn't have been a tax because it originated in the Senate. Like, there's no way that that ruling could be true on its face, if I recall correctly.
Yeah.
And I
Yep.
remember a caller said to me, they have something on Roberts. And I was like, well, that's out of the blue. They have something on Roberts, and people were really convinced of that. And recently, I don't know if you noticed this, a couple of years ago, Justice Roberts' name, I believe, popped up on a manifest for the Lolita Express, Jeffrey Epstein's island plane.
And I had not heard that. If I could just, as an alternative explanation that's
Come
less,
on, come on,
I
Eric.
think that's a great one, but I think he's got political antennae,
Yeah,
and that he's worried that he doesn't want the Supreme Court to lose all of its legitimacy.
his
And
legacy too, maybe.
but I think what's going to happen, because of the reaction to the Dobbs decision and a couple of the other decisions from last year, and now that he has 5 others conservative justices,
Oh,
I'm hoping he's going to learn his lesson that politically, uh, the dumpsters are going to catch on fire anyway. No matter,
he goes
you
with the
might as well,
political winds, which way the
yeah,
winds blow.
yeah, you might as well follow the Constitution now, because if you try to appease the
Yeah.
protesters, they're still going to find something to protest about. You're still going to have Democrats calling you illegitimate, even though you're following the Constitution, that calling you radical because you disagree with them on the reading of the Constitution. I'm hoping that with the moral support he's got from 5 other justices, and seeing what happens.
I guess, I mean, I always hesitate to consider this possibility because it seems so preposterous, but I guess it's possible that Trump put those Supreme Court justices in there because there are actually two teams and he's on one of them. Like, I just assume the whole thing is rigged from top to bottom, but this clearly, I mean, unless another shoe falls and what you get is like this unbelievable pendulous reaction where you have the kind of nasty constitutional amendment they just passed in California yesterday of just an unfettered right to abortion. If they make that like a US, they do it so that they can escalate these things to the federal level. I mean, perhaps he's there just to create reaction after reaction with these Supreme Court rulings, or maybe the worm does turn. I don't know.
I'm hopeful, my individual opinion, that we are due for another one of these constitutional sea changes, and having 6 constitutional scholars on the Supreme Court, that the federal government, the Federalist Society has accomplished its mission of starting to turn the tide of the courts. And maybe it is time we're due for a different form of federalism that's either something like we had before the administrative state. We'll see what happens.
Yeah, that would be very cool.
A period where we're more originalists and textualists.
Both.
Yeah.
Right. Okay. I'm with you there. I can't wait to do this again. Should we think about what we're going to talk about next time, or you want to mull that over?
I'll talk about whatever you want to. I think that a little bit of the history of the progressive era is something that I think would be
Oh,
interesting to people,
y-
and maybe that through the populist through progressive, the way the
yes.
Constitution was amended and interpreted.
I have a book called The Populist Moment that was recommended to me by a really someone who I respect a lot, who's like an absolute total old school liberal. So I'm absolutely certain it's going to come from that point of view. But I maybe I'll do a little homework too this time. That wouldn't that be a treat? So, but I just love this. It's so fun for me. I think it's fun for other people too. And I know it's a lot of work, even just the time. But plus, you spend time beforehand getting all the ducks in a row. Although, anytime I throw anything at you, you know exactly what I'm talking about. So I think you could just wing it if you had to, but you don't because you want to keep it organized. And that's such a pleasure and a privilege. And I love it so much. Can you tell people how to find your business and also the podcast you do with Clint?
Sure. So it's buchanandisability.com. That's where we are on the World Wide Web. We have 5 attorneys help people all over the United States, working with local attorneys if we need to. So look us up there. We also have some videos on YouTube, some other places, buchanandisability.com. And my regular podcast, it's called Of, By, and For the People. On Mondays, we do political commentary, trying to explain the issues of the day, but try to look at it from a big picture constitutional point of view. And then on Tuesday, we do our deep dives, and we are going line by line, literally line by line through the Constitution.
Oh, that's so cool.
Yeah.
I'm sure people will love that. And I cannot wait to talk to you again. You have been listening to Deep Dives with Monica Perez.